Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic today will be luck and timing, the formula for success. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is November 24th, 2024. And you know we do this every Saturday, ladies and gentlemen. Well, the song. The song was called You're the Inspiration, and it was performed by Chicago. That song was released on October 31st, 1984. That was literally 40 years ago, ladies and gentlemen. And I'll tell you a little story that most people don't know about the group Chicago, which was obviously a super group back then. And that is that their original name was not Chicago. Their original name was Chicago Transit Authority. They named it after the bus line in Chicago. And you would see on their album, CTA, Chicago Transit Authority. Well, guess what? We live in a very litigious world, ladies and gentlemen. So the actual Chicago Transit Authority sued them, and they were forced to change their name to Chicago. But you know what? I don't think it hurt them any because they became a mega band and they still perform today. And I think they're just great. Okay, we're going to open it up now to the topic. And what is the topic? The topic is luck and timing, the formula for success. Now, why do I say that? Well, most successful people, and you guys can think about it yourself because most of the people who are listening to me are successful property owners, and they can contribute their success, at least in part, to luck and timing. There was always one part of your life, somebody who ran into, someone who counseled you, some facts that just crossed you upon you, and you seized those facts, you seized that timing, and you became a success that you are today. But it still was based on luck and timing. For example, you could be the best actress in the world, you could be the best singer in the world, and really the chances of getting discovered probably are very small. So it does take luck and timing. Let's talk about the entrepreneurial geniuses of a person by the name of Bill Gates or Steve Jobs. Bill Gates, of course, founded Microsoft Company, and Steve Jobs founded Apple Company. Both became unbelievably wealthy. Their companies rose to levels that have never been seen in all of history of all companies in the world. And of course, these people are geniuses. We were not going to take anything away from them, but it still comes down to luck and timing. For example, if these people were born 30 years before they actually were, computers weren't around. And on that basis, would they be the same successful people that they are as of today? And the answer is probably not. So it really does come down to luck and timing. However, there is one profession, ladies and gentlemen, that is not based on luck and timing. And I'll tell you what that is. That profession is sports. I don't care where you are, even if you're in Duluth, Minnesota. If you can hit the ball out of the ballpark, if you can hit that jump shot, trust me, they are going to find you and they'll catapult you into the sport that you're playing. However, other than sports, I really believe that there's always luck and timing. And now I want to talk about, in terms of luck and timing and how we're going to get into this, I want to talk about my father-in-law. He passed 31 years ago, and due to his genius, he's still supporting the other side of our family with his investments. But Saul Rubin, my father-in-law, when he was 12 years old, he lived in Poland in the late 30s. And you can just imagine, he came home from school one day. He had a large family. All of his brothers and sisters were killed and his parents were killed. He was put into a concentration camp where he stayed doing slave labor for 5 years. And then one night he heard the German Nazi soldiers talking that the war was almost going to be over and they were ordered to kill all the inhabitants of the concentration camp. So him and another friend decided that it made no difference. They might as well try to escape, and escape they did. He then left and emigrated to Israel. And being a survivor of a concentration camp, one of the things that was most dear to him was food. So he actually became a chef, and not any kind of a chef. He became a gourmet chef. He emigrated from Israel to Los Angeles area, where he became a gourmet chef for many restaurants. But he had the wherewithal and the foresight to know that every additional dollar that he made, he saved it up and put it into real estate. And quite frankly, that's the reason why I got involved in real estate, through my father-in-law. And he actually, as to this day, even though he has deceased so many years ago, is still supporting our family. Now, my story was that in 1976, 48 years ago, I became an attorney. And at the time when I became an attorney, there were no employment opportunities. I tried my best to get a job with somebody, but I could not. So I figured I would start my own law practice. And 48 years ago, I've never worked for another law firm. But while I was in law school, my father-in-law had a problem with a tenant. And he asked me, could I assist him in filing an eviction lawsuit? And of course I did. And I somewhat got the concept down while I was in law school of how to do a tenant eviction case. Now, my luck and timing came from the fact that at that time, believe it or not, and even though we see all these commercials on TV, attorneys were not allowed to advertise. Advertising was forbidden by all state bar associations around the country. Well, there was a law firm, which is still around today, called Jacoby and Myers, and they took this case to the United States Supreme Court. And the United States Supreme Court said, of course, lawyers can advertise. That's a matter of free speech, and it's guaranteed. So, of course, at that point, since lawyers could advertise, I immediately started to advertise. And I advertised to do, personal injury accidents, form corporations, do dissolutions. And I said, I kind of know how to do a tenant eviction case, so I think I'll advertise for doing tenant eviction. And I was familiar with these magazines that came from the Apartment Owners Association and other associations. So I said, you know what, I'm going to put my ad in there. Well, fast forward another year, 1979, the city of Los Angeles decided in their ultimate wisdom to institute rent control. So here I was advertising that I do tenant eviction. Rent control came in. Landlords were, of course, freaked out that now they could not control their property. They could not raise rents. So it became important to them that if they did have a tenant and they wanted to do an eviction, that they would find somebody experienced in doing so. And that kind of started my law practice, where, of course, we just specialize in doing tenant evictions. And as you might know, my firm consists of now 29 attorneys and a total of team support of almost 50 people. But we know that the institution of rent control ushered in the destruction of our property rights. It has placed limitations on our ability to raise rent. And this is so regardless of whether the tenant has the ability to pay market rent or not. This is somewhat insane. If we talk about social welfare, you have to qualify for it. And then the populace contributes through our tax dollars to pay those people that are needy and truly qualify it. But the insidious part of rent control is you can have $3 million in a bank account. It makes no difference. You're in a rent-controlled apartment, you're protected. And that was the initiation of the destruction of our property rights. They also limited our ability to control our own property. You have a nuisance tenant. He's creating problems for other tenants in the building. Can you just ask him to leave? No, you have to have cause, you have to bring forth a lawsuit. And more importantly, when you bring forth that lawsuit, you have to have witnesses, which means you have to get the other tenants to come to court and testify against these people. Well, many tenants are reticent to do that. They don't want to be hurt or their cars scratched. So it's difficult to get tenants in nuisance cases to even come to court, even though they are legitimately and truly being bothered by this one tenant. But again, we saw the usurpation of our property rights and our ability to control our property. These statutes also dramatically increase the costs of ownership with all the regulations and what we have to do and the fees that we have to pay to the rent control boards. Again, just drove up the fees for maintaining our building. And then finally, and certainly true in the city of Los Angeles and unincorporated areas of Los Angeles County, they have forced our rights to enforce our property rights. They have stopped us from enforcing our property rights, legitimate property rights. For example, if you have a one-bedroom apartment and the rent is $2,000 and the tenant hasn't paid November's rent, and you're either in the city of Los Angeles or an unincorporated area of LA County, you can't bring forth an eviction at this time. And the reason for that is you have to be above the threshold. This is the fair market rental value. And for a one-bedroom apartment, it's $2,086, which means that if the rent's $2,000, you're below the market value, then at that point, you can't even serve a 3-day notice to pay the rent. The city council and unincorporated areas of LA County are telling you, you've got to wait to the second month before you can bring forth an eviction. Again, what we're showing here is that they're delaying our rights to bring forth legitimate cases to enforce our property rights. Now, we all know that property ownership creates wealth, but we have to be diligent in enforcing our property rights. There's no doubt that these elected officials have created a war by our politicians against landlords, a war that only escalates rent. The taking away of the supply of our units creates higher rent. So what they're attempting to do, which is to make rents affordable, has the absolute opposite effect. What they're doing is creating a lesser supply and therefore having us have higher rents for any time a unit gets vacated. Now, there are strategies for success, and they are definitely related to luck and timing. But you have to use your ability to seize that moment. There has to be proper tenant screening. If you don't properly do tenant screening and you have a bad tenant, you're looking at $20,000 to $30,000 in loss. By the time you go through an eviction case, the lost rent, the rehab, the damage to your unit, you've lost tons of money. Proper tenant screening is what you must do. Also, if you do have tenants that are paying low rent and you have the opportunity to terminate the tenancy, then you should do so. If that tenant is violating a term of his rental agreement, he's altered the premises, he brought in an unauthorized pet, he has strangers living in the unit in violation of the rental agreement, that's your time, that's your opportunity to seize the moment to evict that tenant. And once that tenant is evicted, then you have the right to go to market level. That's your luck and timing of what your tenant did. And last but not least, if you do have low-paying tenants, seize the moment by considering doing a voluntary vacate agreement or a cash for keys agreement. If you do that and you can encourage that tenant to vacate, now you will be sitting there with an apartment that now it can be rented for market value. So remember to seize the moment. That is my discussion on luck and timing, ladies and gentlemen. And now we're going to open it up to our question and answer period. We know the rules. That is, this this broadcast is for informational purposes only. It's not a substitute for legal advice. If you do want to talk to me, it's so simple. If you're in the Zoom meeting, please electronically raise your hands. Also, if you have an existing case with my firm, we do not discuss existing cases, only general areas of the law. And last, please don't be shy. If you have a camera, we'd all like to see each other, and it makes these broadcasts much more enjoyable. And with that, we're going to open it up to our question and answer period. I see here that we have an iPhone. I'm going to ask the iPhone to unmute themselves. Hi there, how are you?
I'm doing fine. Yes, I was looking at your AOA. I missed the live that you had on the AOA web, and you talked about a notice to pay or 30 to know to quit. Now,
Yes,
something
I
new.
can discuss that.
Never heard that.
So what we have is
Okay.
most people don't know this, that if your building is financed by a federal loan, like Fannie Mae or an SBA loan, or you have just one tenant in your building that's under Section 8, and this is all jurisdictions in the state of California and really across the nation as well, you have to serve a 3-day notice to pay or 30-day notice to quit. If you don't do that, then you will lose your case. So again, you have to be in a situation where you are serving a different notice, not just the standard notice to pay, rent, or quit. It's a 3-day notice to pay or 30-day notice to quit. So you've got to basically waste another 30 days. Another reason why you should figure out a way not to take a Section 8 tenant or have your property financed by a federal loan. And again, even if the tenant in question is not a Section 8 tenant, the way the law is written, you have to serve that special hybrid notice.
My goodness, I think I'm in trouble. So, how would the tenant that's in question, how would we know if I have a Section 8 tenant in the building? How would that come up in court? Like, is
Well,
it a way for them to
if he
verify
had any
that?
evidence of
Like, I
that,
have like two Section 8 tenants.
okay, well, if he had any evidence that there was a Section 8 tenant, maybe he was talking to the other tenant. But if it does come up and you haven't served the proper notice, you could definitely lose your case.
All right, thank you so much.
All right, you take care. Moving, let's see here. Let's move to Jim Polina. How are you, sir?
Happy Saturday, Dennis. Good to see you.
And good to see you too. It's raining down here, by the way.
Yeah, it did a little bit yesterday up here, a little bit in Morro Bay and Pismo Beach. So I have a tenant that's actually a corporation that provides housing to adults that need some guidance, some life skill guidance. So they provide housing for the adult in my home along with an employee. So I'm not sure, should I be listing the client of my tenant as an occupant on my lease and their employee?
Well, who is paying you the rent?
The corporation.
Okay, so the corporation is going to be your tenant. Okay, that's who you're listing.
Mhm.
But you should list the other people as occupants.
Okay, so they rotate every vary 6 months to a couple of years. So then I just do a
Yeah,
change of what?
yeah, it's a tough situation because I know my son leases to a kind of like a sober living place, and he's just doing it to the LLC. But you should at least keep a list of the occupants, and when they do change, you should ask him to give you a list of the current occupants.
So if I had to do an eviction, where am I at?
Well, what you're going to do is you're going to sue the corporation That would be the name in the notice. The other people are occupants, but they're not, quote, tenants. They're not paying you the rent.
And so they would be included as far as all others in possession of the house?
That is correct. Everybody would get evicted.
Okay. Second question, Dennis, on this 3-day notice to pay or 30 days to quit with Section 8 or Fannie Mae, Freddie Mac loan,
Mhm.
where do I find if my loan is funded with Fannie Mae, Freddie Mac, or maybe it's been sold? You know, originally it was funded by a different entity and then sold to Fannie Mae, Freddie Mac. It doesn't matter.
It wouldn't be sold. That loan would not be sold. You have to apply. So you would know if you have a federally backed loan because you have to jump through hoops. Trust me, because I know in one of my office building, I have an SBA loan and you know it's a federally backed loan. So
Okay.
there'd be no question about that. And it wouldn't be sold. That's not how federal backed loans work.
I thought Fannie Mae and Freddie Mac buy almost 80% of all loans.
I'm not aware of that, but trust me, it's not considered you're dealing with your lender, so it's not a federal loan.
Okay, thank you.
All right, you take care, sir. Always nice talking to you. Let's move on. Anna, how are you today?
Hi, Dennis. I'm good. Thank you. How are you?
I am fine. You staying dry?
Yes, it only drizzled a little bit. It didn't rain too bad. Dennis, my building's LA RSO, and I'm trying to get clarification on the 90-day notice requirement for rent increases greater than 10% a year. Typically, I raise the rent by the maximum allowable every year. Occasionally, tenants may request to have an additional occupant, which can range from a month or they stay permanently. When I get these requests, I tell them there'll be a 10% increase for each occupant. And many times the tenant doesn't want to wait the 90 days before the additional occupant can move in. Is there a waiver they can sign if they don't want to wait the 90 days?
Okay, so what you're saying, first of all, this is an RSO property
Correct.
in the city of Los Angeles.
Yes.
Okay, so in the city of Los Angeles, if an extra person moves in and they're there longer than 30 days, you have the right to raise the rent 10%. If you've already raised the rent once in that year, then that means that the next rent increase within any 1 year period will exceed that 10%, which means it's a 90-day notice. So in order to make it legal, you're going to have to serve a 90-day notice, but there is another way around it. And that would be that you can have them sign a new rental agreement acknowledging that the tenant, there is an additional occupant there, and that's why the rent is being raised 10%. As long as they sign a new rental agreement, that's not considered, quote, a rent increase, which would trigger a 90-day requirement. So just get everybody to sign a new rental agreement, acknowledge right on the rental agreement that this is 10% more than the previous rental agreement because an additional occupant moved in, and I think you're fine.
Okay. And then when that person moves out, do I revert back to the old rental agreement or do we just, I
And
mean,
the answer is the city of Los Angeles says you have to reduce the rent.
okay. Thank you, Dennis.
And thank you. Well, let's move on to Marco Donato. How are you today, sir?
I'm good. How are you? I have a very general question. I'm thinking about becoming a paralegal. And I just want to, it's only 5 months, and I'm just wondering if in the landlord tenant that they use paralegals and what you think if a 5-month course certificate AB, it's called, is worth doing.
I think it is worth doing. We do definitely have paralegals as part of our staff. They do a wonderful job. Obviously, everyone is supervised by the supervising attorneys at our office, so no work gets out without it being checked. Actually, we have two attorneys check everybody's work. You know, it's funny that this is only my 48th year in practice, but do you know when I write up a case that I personally take? I hand my case over to another attorney to review my work too. So, But in terms of specifically, I think it's worth it. The time period is not that long, only 5 months. But once you get your feet wet in the practice, then you might want to consider going to law school. It's usually a 3-year course, though they do have it expedited now for 2 years only. And if you like being a paralegal, maybe you're going to also, or a legal assistant, maybe you'll also like being an attorney as well. So consider that.
It's just a lot of money, but thank you. Yes. Yes.
I had a law professor when I first started law school. One of the people in the class, a woman student, said, made a remark that, gee, law school, 3 years. And the professor, who I so admired, her name was Beverly Rubin, said, look, honey, she says, the 3 years are going to pass whether you're here or not. So I always remember that.
Thank you very much.
All right, you take care. Let's see. Bear with me. Okay. Let's move on to Raul. How are you, sir?
Greetings. Thank you so much for putting this on for us. You're great. I love this. Question. So I have a single apartment. There's a tenant that's been there for a good about 14, 15 years. This is a building we recently acquired now about maybe 6, 8 months ago.
Mhm.
The rent on it is way below of the market value of that, and we'd like to change that due to the fact that we need to change that. So if we were to offer them to vacate cash for keys, and the rent for the single that they're paying is only like $750, but market value in the area that the building is in is around $1,900 for a single. What would be a reasonable? I mean, since we're asking them to leave, are we asking them to leave at the $700 level? We have to reach a market level money to give them cash for keys to move out. What is reasonable?
You're asking what you should be offering the tenant to move?
Yes, sir.
Okay, so it looks like based on your example that you're going to be gaining $1,100 per month.
Exactly.
Correct? Let me
Exactly.
ask, and I've done this before. Let's clear our mind, and we're going to talk about a brand new subject, sir. And here's
Okay.
here's the brand new subject. If I made a deal with you that you give me $30,000 and I'll give you $1,100 for the rest of your life, and this is guaranteed, would you accept that arrangement?
So if you agreed to give me
No, you're
$30,000,
giving me $30,000
right?
and guaranteed for the rest of your life, I'm going to give you $1,100 a month.
That doesn't sound like a good deal to me.
Well, it sounds like a good deal to me.
Okay, explain to me why.
Well, when are you going to get your money back? Your investment would be back in less than 30 months, right? Probably about 25, 26 months. And then
Okay.
you're going to get $1,100 for the rest of your life. If you put $30,000 in a bank account, what would you get per month?
About 2%, 4% maybe
No, per year. What
per
would you
year.
get
Yeah.
per month?
I got it. Okay. Nothing. Zero. Next to nothing.
Right.
Yeah.
So you're asking me, now let's go back to your example. You're asking me what's a fair amount? If you're going to get $1,100 per month more, I think that's $30,000. Also, you know, and I know that many buildings are the value of the building is determined based on a multiplication factor of the rent.
Exactly.
And usually that's around 17 times the yearly gross. Well, if you get an extra $1,100, that's going to be what, another $13,000 per year times 17. How much is your building worth more now?
Another, more than I'd have to
Two,
do the
300,
math. It would be a lot more.
200,000? Yeah.
Excuse me? Yeah.
So that's the way I look at it with doing a cash for keys, or we call it a voluntary vacate. You definitely want to have a specific agreement prepared. There's also disclosure statements that have to be filed with the city, certain language. Also, as I've said in other telecasts, that if the tenant takes the money and doesn't move in the city of Los Angeles, you don't have the right to evict based on that. You'd have to sue them for the money back. We have a special voluntary vacate agreement, which would actually allow us to bring forth an eviction against this tenant. So be careful if you do get that deal. But I mean, you don't have to start with 30. You could start with, hey, I'll give you 2 tickets to Disneyland if you're willing to move. And if he accepts that, that's a proper amount because there is no specific amount on a voluntary vacate agreement. There's no set amount. It's whatever the two of you agree, from $1 to $30 million.
Got it. Okay. So I guess what would be reasonable would be what I would consider to be reasonable.
Exactly. But again, you've got to give them
Something.
something.
Right. Right. All right. Perfect. Thank you so much.
All right, take care. Okay, we're going to move on to, let's see here. Let's move on to Belinda. How are you?
Hello.
Hello, Belinda.
Hi, I'm good. How are you?
I am good, thank you.
Awesome. So we have a fourplex property in Valley Village, and we're about to start a remodel of the garage into ADU. And this will mean parking will no longer be available for all 4 residents, except we'll have 2 spots in the back once the remodel is done. But for the 2 that no longer have parking, are we required to reduce their rent even though parking was never in their initial lease?
Well, when they moved in, were they always parking there?
Yeah, there was always parking. So for these 2 tenants, they've lived there about 7 to 10 years, but there is free street parking available. So there's a lot of parking on the street.
Okay. In your rental agreement, if you look at every word in your rental agreement, it probably does not say the word toilet. So on that basis, you'd be able to remove the toilet from the rental agreement because it's not contained in the rental agreement.
Yeah.
And my point is that if they've been parking there for their entire time, even though the rental agreement never talked about parking,
Yeah.
they have parking as part of their rental agreement, just like they have a toilet as part of their rental agreement.
Yeah. There was a section for parking in there, but they never put any parking spots in there.
Right. And I can understand that. But again, they've been parking there for
Yeah.
years.
Yeah.
So
Okay,
the
so
city of Los Angeles does require that you give them a corresponding decrease in rent.
okay. Is there a
And they
specific
have,
amount?
yeah, they do have an amount. There's a bulletin that they produced a couple of years ago. For parking, it's anywhere from $70 reduction per month up to over $200. And that's determined based on how much street parking there is. If there's a lot of street parking, then the parking spot is not worth that much. So the
Oh,
way
okay.
you do this is you serve them with a 30-day notice telling them in 30 days they can no longer park on the property and that
Okay.
you're going to give them a corresponding decrease in rent. So let's pretend you say, I'm going to give you $100 off your rent. Now,
Yeah.
they can object to that, and then they would make a complaint to the Los Angeles Housing Department. And then by making a complaint to the Los Angeles Housing Department, they would have a hearing, and then the hearing officer would determine what is the reasonable reduction in rent that should be applied.
Oh, got it. Okay. And does it matter which one because we have to remove 2 parking spots. Does it matter which one we remove? If
No, it doesn't matter at all.
Okay, so we get to choose,
Yes, you
basically.
do.
Okay, perfect. And then my second question, if we suspect they have other people living in their unit that are not on the lease, how do we go about that? Do we write them a letter or?
Well, I mean, if you're interested in evicting the tenants, I wouldn't write a letter. The first thing I would do is serve them with a notice to perform or quit, giving them 3 days to get rid of the stranger. At the end,
Oh,
at the end of the 3rd day, if the stranger's there, then we have the right to evict everyone from that unit.
got it.
How do you prove that they're living there? Well, it's called eyes, your 2 eyes. If you see the same people coming and going,
Yeah.
then you are then you know that they're living there. Maybe you see the guy in the morning, you see the guy coming home in the evening, maybe you see him using a key to gain entrance to the property, or better than that, there's another way which we can do this, which is everybody who's listening to me now, I'm going to become a psychic. And I'm going to tell everybody in this room, I'm going to tell everybody something that I know about everyone. And that is all of your cars are parked outside right where you are right now. If you have a car, it's parked right outside wherever your location is right now. And the reason why I'm saying that is if the stranger has a car, you don't have to know that the stranger's inside the unit. All you have to do is see where his car is parked and make a note of that it's parked overnight. And that would prove that. So, but you can get other tenants to come to court or manager or something. They'll say, yeah, this guy's living there. That's usually not a difficult thing to prove, Belinda.
Okay. Okay, perfect. Thank you so much.
You have a good day. And we are moving on to Daniela Moskovitz. How are you?
Mute. Hi, Dennis. Thanks for doing this. What is your suggestion for the amount of liability for renter's insurance and for auto insurance for the parking and storage agreement?
Well, I mean, this is up to the tenant. The renter's insurance insures the tenant. So we don't care what kind of insurance they get. What we want to make sure is that the tenant, and that's like a provision in your rental agreement, and you can check my rental agreement, which has that, which states that if your personal property is damaged or you have to temporarily relocate because of no fault of your own, maybe there was a flood, maybe we have to tent the building for termites, then you can only look towards your insurance company for compensation. You specifically exclude me. So it's not a matter of telling the tenant what limits to get. It's much better to just that you're just trying to avoid your liability in the situation.
Got it. Second question. You mentioned in the cash for keys discussion just a moment ago that there is a disclosure agreement that has to be filed with the city. Do you have that disclosure agreement online?
I don't, but the city does. So just if we're talking about the city of Los Angeles,
Right.
Just do cash for keys disclosure agreement, city of Los Angeles, and that'll be there. And technically, you're supposed to offer that to the tenant as you're trying to negotiate the deal. And for example, in those types of agreements, there's a 30-day cooling off period. So if you do a voluntary vacate agreement, you have to state right in that agreement that the tenant has 30 days to change his mind, and a sleuth of other requirements as well.
Great. Okay, thank you.
Thank you, Daniela. I got your name right this week. Let's move on to Tiffany. I shop at your store. No, I don't shop at your store. Are you there?
Yes, I'm here. Hi, Dennis. I have a question. I served my tenant a 3-day notice through your office, and the last day was Friday. So Monday they're going to file for the unlawful detainer, but the tenant tried to deposit.
Wait, we remember we keep this only to general questions only. So if you could rephrase it, we don't talk about specific cases.
Okay, so if a 3-day notice was served and the still trying to deposit money for rent, what do you suggest?
Okay, so has this notice expired?
It expired Friday.
Okay, so if the tenant puts money into your account, don't worry about it. No big deal. What you're going to do is once that money clears, you will send your personal check to the tenant with a little note saying you've made an unauthorized deposit into my account.
Oh, okay.
A lot of times they'll Zelle money into people's accounts, and if that's the case, either Zelle it back or again, write out your own personal check, send it to the tenant with a note saying you've made an unauthorized deposit. Now, if the tenant doesn't cash your check, then I don't care. As long as you mailed it, good if they don't cash it. But as long as you mailed it, then that's all we care about.
Okay. Okay. Thank you.
And thank you. We are moving along. And if anybody's got questions, I think we're going to have more time for more questions. So electronically raise your hand. We're going to move on to a wonderful person by the name of Tony C. How are you?
Thank you, Dennis.
Hello, Tony.
Yeah, I like your topic, lack timing and I would add opportunity.
Yes.
and I am one of those guys, that came to this country with $300 in my pocket. Now I have a couple of rentals, under my belt, and it couldn't happen only in the United States of America,
Yeah,
so
it is amazing the wealth that has been created where people just have to apply themselves. And of course, when that luck and timing appears that you jump at it. And everybody, if you really think about your life, your own personal life, and really what was that moment that happened and did you act accordingly? For me, in terms of my law practice, it was that Supreme Court said you could advertise. I started advertising for evictions, and then all of a sudden, LA starts rent control, and it became an ongoing war between landlords and tenants. So, but everybody think back at that moment in your life where you seized the opportunity, and also think for the future too, when those opportunities arise that you need to seize the moment.
that's
But
right. I
but
just
look
want to
at
thank
you
you,
coming
Dennis.
as an immigrant to this
Yes.
country, and look what you've accomplished.
I just want to thank you because you are here every Saturday, for us. And, I won't ask any questions, just want to say a statement. Thank you so much.
You're very kind, Tony. And we are moving on to a regular, Mr. Sam. How are you?
Yes, Dennis, can you hear me?
I can.
Okay, very good. So the question is this, kind of somewhat related to the previous caller's question. The if somebody pays by cashier's check, an official bank cashier's check, suppose you're moving in a tenant, they're paying the deposit and first month's rent. Is it possible for them to gain possession and then cancel or somehow call their bank and say that this check is lost or something? In other words, the
Yeah.
security, should the landlord only accept actual green cash?
Well, a listener to this show gave me the best idea. Number one, I've seen it where they have counterfeit cashier's checks.
Oh,
So it looks like it's a Chase cashier's check, but it's not. It's officially signed and all this. It's counterfeit. So, and can you place a stop payment on a cashier's check? And the answer is yeah.
mhm.
So a caller gave me an idea, and now I immediately institute this because this show is really a learning experience, not just for the people listening, but for me too. I've learned so much by talking to all of you wonderful people. And the caller gave me the idea is that you do not give the keys until the check clears. So you can take a personal check, that's fine, but you're not getting into my apartment until the money has cleared my account. That's the only safe way to do it.
How long does that usually take to clear?
Depends really on the bank. So you should just call your bank and
Okay.
and you'll see that it did clear.
Okay.
Sometimes banks can take a little bit longer, but you need to call the bank or check your account to make sure, because I've seen it where it says it's posted and then magically they say it's been returned.
Oh,
So make sure that you contact your bank to make sure, even for a cashier's check. Now, if they
okay.
wire the money into your account, then that certainly would be fine.
Okay. Oh, thank you. Thank you so much.
All right, good question, sir. We're moving on. And again, we have time if anybody has questions. Today is a good one. We're moving on to Steve Lopez. How are you?
Hello, Dennis. How are you?
I am fine, sir.
I've got a little fun fact for you. I'm also an attorney, and I refer all my eviction cases to you.
Oh, that's very kind of you.
Yeah, and actually before I became an attorney, I needed an eviction, and I contacted you back in the '90s, and you did a real good job for me.
And I'm still doing it. Unfortunately, I go back to the
no,
80s.
that's great. That's great. So I got a question for you here. It's similar to one that someone already asked. I have a triplex in Southgate, which has a 2-car garage and a carport. I'm going to be making a ADU there, so the carport area is no longer going to be a parking spot. So it's not under rent control. Under this, do I have to give a discount to the renter? And I'm using your rental agreements on all the units.
Well, first of all, you said it was in what city, please?
Southgate.
And this is a single family home or apartments?
It is a triplex. It's going to be a quadplex after the ADU.
And I presume this property is over 15 years old.
Yes, it is. Yes.
So you are subject, young sir, to statewide rent control. So you are under rent control because every city in all of California is subject to AB 1482, statewide rent control, the Tenant Protection Act. So you're going to have to give some sort of a discount in rent. They haven't really come out with any specific formula for the state, but again, you're taking away a service that they're entitled to, an amenity, parking. So you're going to have to offer them something less in rent. And by the way, you are under rent control. For example, the most you can raise the rent in LA and Orange County under statewide rent control is 8.9%.
Okay. So I don't practice landlord tenant anymore, and I know the laws changed a lot. I don't deal with the headache. I just send it to you for the headaches now. I refer all the cases there.
And I'm appreciative of that.
All right, Dennis, thanks a lot.
Thank you, Steve. Good weekend for you. Moving along to Camille Dudley. How are you?
I'm fine, thank you. I have 3 units, and it's all families living in all the 3 units, and we want to do an eviction. They've been nuisance tenants. I've got numerous citations that have been written against the property. They refuse to comply with the commands of the citations, and so I'm just wondering, is it possible that we won't have to pay them to leave because of all the money we've spent on citations?
Well, first of all, if you're evicting a tenant based on fault, that is that the tenant did something wrong, there never is relocation. What city is this, please, Camille?
Pasadena.
Okay, so there's never relocation. If the tenant is violating the terms of a rental agreement or violating some sort of a city ordinance, then that would be a clear fault case, and we could immediately do that eviction if they haven't complied.
Okay. They have not complied.
What are we talking about? What are they doing wrong?
Well, trash, animals, unregistered vehicles. We had a inspection just recently, and we had the vehicles towed out. The city was there, plus the police department. And as soon as we left, they put everything back in place. And it's just continuous. It's been going on since we've owned the property. And
Okay,
we've had the
so
property since. I'm
these
sorry.
these are all wonderful reasons that we could immediately bring forth an eviction against these people. So I suggest you call my office on Monday.
Okay, we will do that. Thank you very much.
Thank you, Camille. Happy to assist you. Arlene, how are you today?
I'm good, Dennis. How are you?
I am fine, thank you.
Good. Thanks again for all you do. I learned so much. This is kind of off topic, but I just wondered maybe at one point, if you have any knowledge about it, you might share it with us. LARSO, Mid-Wilshire area, and we're hearing that a lot of insurance companies are leaving and they want us to do these electrical retrofits and the roofs and everything. And I didn't know if you had been on top of anything or had any suggestions of what people can start doing.
Well, a lot of single family homes, such as the one I'm sitting here now, has been canceled by Farmers Insurance because we're in a quote fire area. And we're seeing this, I mean, insurance companies, I don't fault them per se, because their job is to make money like any other business. And when they realize that the risks are too high, then there's no reason to offer insurance anymore. So you've just got to scout around. But again, if they're asking you to do some electrical work, what they're afraid of, obviously, is that the building's going to burn down, and that could obviously subject yourself to a lot more trouble than just merely that. So if they're asking you to upgrade, you just got to bite the bullet and do so. I mean, we have a situation where buildings are built in the 50s, and it was not anything called a computer. Now we've got satellite dishes and TVs and microwaves, all these things that exist. And quite frankly, we do have to beef up our panel.
Yeah. All right, thank you.
Thank you, Arlene.
Have a good Thanksgiving.
Thank you. Appreciate that. And Norton Griffiths, it looks like. How are you? Norton Griffiths, would you like to unmute yourself? Okay, Norton. We're going to move on to.
Hey, no, I've got it.
Oh, good. Gotcha.
I'm new to your program. Do you serve Riverside County?
Yes, I do. We do Riverside, San Bernardino, Orange, LA, and Ventura. We do not do San Diego anymore.
Okay.
Also, we do Bakersfield and Kern. So
let me ask you, I had to evict a tenant in Riverside, single residence. I got a judgment for $10,000. I've contacted him and asked him how he wants to pay it off. He's not replying to me. Do I have to file a lien against him or?
Okay, well, the process is obviously your tenant's not going to pay you. You had to go through an eviction case.
Right.
So it's going to be your obligation to go through collection procedures. So the first thing is you have to see if you can find assets. So what are assets? Assets are a bank account where he has money in it, or know where he works so that you can either garnish his wages or attach a bank account. Once you have that information, then you can get something called a writ of execution for money that would be issued by that same court. You have to do what they call sheriff instructions. And then the sheriff will then grab money or garnish their wages from his employer. But again, this generally is above the pay scale for most lay people. And that's why most people just would give it over to a collection agency. My firm obviously does collections and we do a wonderful job. But of course, it's on a contingency fee basis. There's no upfront money. But most collection agencies, and such as mine, charge 50%. And the reason why we charge that is because in a lot of cases, we'll spend a lot of money. It's not going to be borne by the holder of the judgment. And we spend money, but we don't find anything. You know, if your tenant is living on Skid Row, there's no basis of collection. However, we keep doing it every year. We search, and sometimes not in the first year, the second year, the third year, maybe even in the eighth year. We keep searching every year until we find something. So it's probably best to just give it over to a collection agency. And even if we didn't do the judgment for you, we'd be willing to take it.
All right, what do I do in a situation? I got the $10,000 judgment by the court, but after he moved out, I had to spend another $4,000 refurbishing the house. And of course, actually, I spent a lot more than that, but I used his security deposit.
To the extent that the security deposit didn't cover the damage, then you'd have to bring forth a separate lawsuit, which I would recommend in small claims court. It costs you basically nothing, and you can obtain a judgment. Small claims jurisdictional limit is right now $12,500.
All right. Thank you very, very much.
Thank you, sir. Appreciate your coming in. Kevin Davis, how are you today, sir?
Hey, Dennis, thanks. Two quick questions. I was looking on the site. You used to have on there for vacant properties a notice to send to the sheriff and LAPD. I don't see it. Did you take it off, or am I just not seeing it?
Go into the place on the website, which is in, I believe, the gray buttons up on top that says legal issues.
Legal issues. Okay.
And if you click in there, I've got a lot of legal issues in there. It talks about interest on security deposits that that LA is requiring, which can be a killer in an unlawful detainer action, I might add.
Yeah.
So I have a lot of legal issues there, but that's one of them is that trespass.
But is the form? But you had a form before to deliver.
And the form is there.
Okay, great. Okay. Second question. I know the balcony inspection thing got postponed till, I think, 2026. I'm trying to figure out, is it 3 or more units on a property, or is it 3 or more units in a building?
I think it's 3 or more. Okay.
But if I have a triplex in front and a single family in the back, which I do.
But generally, you're not going to have a balcony in that situation, but it's 3 or more units. So if there's a balcony or a staircase, then you've got to comply with the law.
Okay, so even if it's so I've got the I have a 3-unit in front that has a balcony and stairs, and I have a single family in back that has a balcony. So they
Yeah.
both would.
Yeah, you're going to have to do that. But
Okay.
again, they gave us a reprieve
Yeah.
till January 1st of 2026.
Okay. Thank you, sir.
Thank you. We are moving on to, let's take a look. Simon, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Simon.
How you doing? Thanks for taking my call. I'm so sorry I cannot turn my camera because I do not have a camera on this computer.
It's okay. Get one by next week. That's what I'm telling
I
you.
will. I will try to change this. I have
No,
a
I'm
question in regards.
Just kidding.
Yeah.
Yeah.
I have a question in regards to renting to Section 8. Is there any law that requires a landlord to rent to Section 8? Because I do have a few units which is vacant, advertised, but all I get is a Section 8 client.
Okay, so here's the deal. You have to rent to Section 8. You can't just summarily reject them on the basis that, hey, I don't rent to Section 8. That would be a violation of California law, which was instituted a couple of 3 years ago. There used to be a thing I would tell my clients saying, don't worry about it. You don't have to rent to them. Just run their credit. Their credit will not look good. And then you'll just reject them on credit reasons. However, in January of this year, 2024, you cannot reject a Section 8 tenant based on credit. I know that's insane. If the tenant can demonstrate his, quote, ability to pay his share of the rent. So if his share of the rent based on Section 8 subsidy is only $200, if he can show you that he can pay the $200, notwithstanding he's got poor credit, you now have to take him. However, and I've been saying this all along, there is another way around this, and that is as long as you always rent your units to applicants on the basis of a month-to-month tenancy only. Do not rent on the basis of any 1-year lease. Section 8 will not accept the tenancy unless it's at least a 1-year lease. So on that basis, if you are going to rent it, whether it's Section 8 or not, you're only offering month-to-month tenancies. That will get you past the requirement to take a Section 8 tenant. However, another news flash, Glendale passed a statute. If you got property in Glendale, you have to offer the tenant a 1-year lease. They don't have to take it, but you have to offer them a 1-year lease. So in Glendale, you're kind of stuck. You could offer a 1-year lease, but kind of say, but I prefer you to take month to month. But you do have to offer a 1-year lease in the city of Glendale.
Well, I have another question to fact. A 1-bedroom voucher, usually they come back and they're asking for 2-bedroom because the price is low and they want to move in with a 1-bedroom voucher to a 2-bedroom apartment.
Well, you certainly don't have to do that because obviously Section 8 is not going to pay the same amount for a 2-bedroom versus a 1-bedroom.
Even though if it's advertised for the same amount of a 2-bedroom, let's say
you advertise a 1-bedroom and a 2-bedroom for the same price?
Yeah, it's in the city of Lancaster.
Well, then I think you're stuck. Then I think you should change your business model. I think you should definitely offer 2 bedrooms more than one. Who wouldn't take the 2-bedroom at that point if it's the same price as a 1-bedroom?
Exactly. Okay, thank you so much.
Thank you. Guess what, ladies and gentlemen? The Denver Nuggets are playing the Los Angeles Lakers tonight. And I'm going to attend, which means I got to get out of this broadcast right now. So I do appreciate everybody tuning in. I'm off to the crypto.com. Thank you very much. You know that we'll be doing it next week at 3 p.m. If you are on the Zoom meeting, if you're on YouTube, please subscribe to my channel. It does help me out a bit. And once again, everybody stay dry and have a great weekend.